there, on this week's edition of Your Weekly, our chat with the former Chief Judge of Lagos State, Justice Aya Phillips, is a real eye-opener into some of what it takes to become a judge. Now, President Goodluck Jonathan has commissioned the new ultra-modern Federal High Court complex in Asaba, the Delta State capital. The President believes that the presence of the High Court in virtually every state of the Federation will bring justice closer to the people.
Members of staff and senior judicial officers of the Federal High Court, the Governor of Delta State, Dr. Emmanuel Udwara, and other government functionaries seated here for the purpose of commissioning the newly built Federal High Court in Asaba, the Delta State capital. The Chief Judge of the Federal High Court, Justice Ibrahim Auta, seizes the opportunity to commend the state government for its efforts.
This building, apart from being an eloquent testimony of our determination to enhance the administration of justice, it is also our own modest contribution to the present transformation agenda. I have to put it on record also that His Excellency, the Executive Governor of Asaba, our Delta State, has done a lot also in the commissioning of this building.
The absence of President Goodluck Jonathan is filled by the Delta State Governor, and in his speech, he praises the Federal High Court for implementing innovative reforms.
Let me also use this auspicious occasion to commend the Chief Judge and other justices of this court for their hard work and immeasurable support for this administration resolve to hold accountable all perpetrators of terrorist acts across the country. I have been duly informed that the practice directions issued by the court has contributed significantly to the reduction of trial.
Flanked by Justice Auta, the Deputy Governor of Delta State, Professor Amos Ntwama, and other senior judicial officers, the Governor commissions the new court premises. This is the second High Court to be built in Delta State, the first being in Warri. With this commissioning, expectations are that facilities here will not only be utilized and maintained, but will also add value to justice delivery.
100 million naira is how much Aminu Sadiq Oguche is asking for from the Department of State Services as damages for unlawful detention. Aminu Oguche is alleged to have masterminded the twin bomb explosion in Nyanya, Abuja. He has also demanded a public apology in 2 national dailies. In a lawsuit filed for enforcement of his fundamental human right, Oguche, through his lawyer Ahmed Raji, told the court that his continued detention by the State Security Service is illegal and unconstitutional. He therefore asked the courts to order his release or his trial in court. His lawyers also asked the Minister of Justice and Attorney General of the Federation, Mr. Mohammed Adoke, to be invited by the Federal High Court Abuja to address the legality of Section 27 of the Terrorism Prevention Act. The law allows for prolonged detention of a suspect against Section 35, subsection 4 of the Constitution, which stipulates that a suspect must be arraigned within 2 months of detention.
We are not saying if there's anything against him, he should be freed. We are saying charge him to court or release him. That is all we are saying. Because he's been there since July 15, 2014, which is in excess of 4 months. And the Constitution, by virtue of Section 35, frowns at that.
Proceedings in the application filed by the Speaker of the House of Representatives to commit the Inspector General of Police to prison for alleged contempt may have to wait for another 1 week. This is due to 2 applications for stay of proceedings filed by representatives of the Speaker's constituent. The applications for stay of proceedings were hinged on the notices of appeal filed against the ruling of the court, which on Monday disallowed them to be joined as defendant in the suit.
The application to join was refused, and we have appealed against that decision on behalf of our clients. And we have asked the court that until the Court of Appeal can determine the matter, proceedings should be stayed.
Tambuwa's lawyer, however, asked the court to adjourn the matter to enable them respond to the application for stay of proceedings filed by the parties seeking to be joined.
The application for joinder was filed. We filed a counter affidavit to it because we saw it that it was likely to delay the expeditious determination of our substantive suit before the court.
But lawyers to the defendant opposed the application for adjournment.
It is such a case that all the lawyers must ensure that it is dispensed with as quickly as possible.
Well, we were here today to take the application which they filed, that's the plaintiffs, trying to commit the Inspector General of Police. It speaks volumes that they were not willing to proceed with the application.
Justice Ahmed Mohammed adjourned the case to the 9th for hearing of applications seeking leave to appeal, stay of proceedings, and one seeking an order compelling the Inspector General of Police to appear in court. Meanwhile, a Federal High Court judge assigned to handle the case against House of Representatives Speaker Aminu Tambuwa has withdrawn from the suit. Justice E.S. Choko took this step after a petition filed by Honorable Tambuwa with the National Judiciary Council (NJC) challenging the assignment of the case to him. The suit filed before the jurist sought to compel the Speaker to vacate his office following his defection from the PDP to the APC. The suit also prayed the court to allow the Deputy Speaker, Emeka Hedioha, who is in the majority party, to take over as Speaker. Citing his lack of confidence in Justice Chukwu, Tambuwa appealed to the President of the Federal High Court to reassign the suit to what he calls a neutral judge. It's a question of who knows the law better in court, as the council argued back and forth on issues bordering on the duties of the coroner's court, whether the coroner should stay proceedings pending the determination of the application before a high court, or whether the obiter dictum of a superior court is binding or persuasive on a lower court. The applicant prayed the court to suspend any action as it relates to the invitation or witness summons of Prophet Temitope Joshua to give evidence on the death of over 160 people when a building collapsed at the synagogue church. His counsel, Lekon Ojo, added that they wanted a limited stay on the matter and not a total stay. In response, the counsel to the state government, Adeni Rongbolahon, argued that the applicant had not shown evidence to expect the application of the coroner's discretion in granting the stay of proceedings. He insists that since the inquest began, the applicant has not supplied any witness, and it took 3 months for the name of the contractor to be supplied. He added that the obiter dictum of a superior court is not binding on a lower court, but merely persuasive, and there was no law stating that proceedings should be stayed because an application for judiciary review is before a high court. It's been a wonderful program. Thank you so much for being a part of the program. Please don't forget to send in your comments and your questions via the address on your screen. I'm Victoria Idu. Thank you so much for watching.